case briefs, and so much more. LSData's got what you're looking for.
In a 2011 breach of contract case, Hawa v. Moore, the Court of Appeals of Indiana focused on the principle that the non-breaching party must minimize their losses caused by the other party's breach. Property owner Mike Hawa hired contractor Gerald Moore to install a recycled concrete base for a parking lot, agreeing on a price of $12,000. However, following a dispute regarding payment, Hawa filed a breach of contract claim in small claims court, leading Moore to file a counterclaim. The court ruled in favor of Moore, awarding him a judgment of $4,745, later reduced by $750. Hawa appealed, claiming the court improperly calculated damages and denied him due process. The Court of Appeals found that Hawa failed to provide sufficient assurance of payment, ruling in favor of Moore, but reducing the awarded damages due to Moore incurring unnecessary costs related to transporting materials. Ultimately, the judgment was affirmed in part, reversed in part, and remanded for a $750 reduction in Moore's damage award, totaling $3,995. Moore was not entitled to a $1,500 hauling fee, though he received damages for the $2,000 rock cost. The court rejected Hawa's due process claim.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.